Good evening, everyone, and welcome to the Robert J. Dole Institute of Politics here at the University of Kansas. My name is Sophia Herrera, and I am a member of the Dole Institute Student Advisory Board, the official student organization of the Dole Institute. I'm currently a junior studying political science and Spanish on the pre-law track here on campus. Across campus, I'm involved in KU's Young Democratic Organization, Phi Alpha Delta Pre-Law Fraternity, and the Latin American Student Union Org. Last year, though, I did serve as the social chair of the Dole Institute Student Advisory Board. The Dole Institute of Politics strives to promote a new era of leadership that uses politics to bring people together through opportunities that emphasize bipartisan cooperation, public service, and civic education and engagement, all of which is inspired by the leadership and services of Senator Bob and Elizabeth Dole and the enduring civic contributions of the greatest generation. The Student Advisory Board is an integral part of this mission, providing members with experiential learning and job opportunities across access to financial assistance and networking opportunities with special guests. If you are a student here at KU and would like to join the Student Advisory Board, please email us at dolesab@ku.edu or speak with a student worker after the program. Before we begin, there are a few reminders I'd like to take a moment to tell you all. Following tonight's program, a video recording will be available to stream on demand or on our YouTube channel, where you can access a full catalog of our past programs. A loop hearing system is also available to use if you have a T-coil hearing aid. The Institute also has a limited number of listening devices. If you have questions about the loop system or if at any time have difficulty hearing, please alert one of our staff members. Please take a moment to familiarize yourself with the marked exits in the room. In the event of an emergency, please make your way to the nearest marked exit. Please follow the instructions of all staff members and exit the building if necessary. Following tonight's interview, a limited number of audience questions will be answered. If you are part of our audience or virtual audience, you can submit questions via email at dolequestions@ku.edu. The Dole Institute aims to foster civil and respectful discussion around important and sometimes difficult topics. Please frame your questions with this in mind. Finally, I'd like to remind you all to please silence your cell phones or place them in Do Not Disturb mode. Now, please join me in welcoming Director Audrey Coleman.
Good evening, everyone. Thank you so much for being with us this evening as we recognize Constitution Day. And I'm going to ask you, when is Constitution Day, folks? Was it September 17th? And I know Barbara's got some more recognition for us to do here in a moment. Again, thank you for being with us as we discuss health care in the U.S. Constitution, contested care, health law at the Supreme Court and beyond. And we're excited to have Professor Cohen with us this evening. And also it's a special treat for us too to have our former Student Advisory Board member, Student Advisory Board alum, Jesse Burbank. And some of you folks in the audience will remember that Jesse was none other than Jesse, the voice of the Dole Institute, many years ago. So we are anticipating this conversation for many, many reasons, and I want to thank a friend of the Dole Institute, Mark Johnson, for his support in making Constitution Day happen. Before I turn it over to Barbara and our panelists, I want to invite you back to the Dole Institute next Tuesday, the 21st. We have a morning problem. So plan to come and visit us at 10 a.m. on Tuesday morning, the 21st. That evening at 7 p.m., we invite you to join us for Why the Armenian Genocide Still Matters. That's a companion to our exhibit Dole and Dr. K that's in the Elizabeth Dole Gallery and Reading Room. Our senior associate, or senior archivist, Sarah Gard, will be moderating a conversation with Alice Kalikian, who is the daughter of Dr. Hampar Kalikian, the surgeon who rehabilitated Senator Dole after World War II, and Michael Babilian, who is a journalist, served as our research fellow for Armenian advocacy. And they have a very interesting conversation prepared for us that evening. And then finally, Wednesday, October 22nd at 4 p.m. for discussion group. Joni Wickham, our fall fellow, will be back with her guests, John Holt, Fox 4 News of Kansas City, John Holt, and Mary Sanchez, also a Kansas City-based journalist, for a conversation conversation about civic engagement and journalism. Is there a connection, and should there be? So timely topics all. Thanks so much for being with us. Now please join me in welcoming Associate Director Dr. Barbara Ballard, our Student Advisory Board alum Jesse Burbank, and our guest this evening, Professor Glenn Cohen. Thank you so much.
Thank you. Thank you, Audrey, very much for your introduction. Before we start our presentation, we always recognize Constitution Day. And usually I am standing there because I'm introducing what happens and I have a bell. I did not bring a bell with me up here, but some of you would have received bells when you came in. And actually, I should have given my two people that they had bells as well. So what we're going to do first is just read, as you know, in September 17th, 1787, the Constitution was signed by 39 of the 55 founding fathers. In 2004, President George W. Bush signed a bill designating the 17th of September as Constitution Day. And, you know, and that was a whole deal that you went through. And we would do things on West Coast Beach, and it would be the West Coast, the Midwest, East Coast. And Colin Powell at the time was the person that said we would all, at that designated time, which was 11 o'clock, that one, 12 or 1, do the preamble to the Constitution. So in starting Constitution Day, for those of you that have the bells, would you please ring them for us, and we will repeat the preamble to the Constitution. Are you ready? Let's go. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. Ooh, what a nice sound that you had. Ring. Thank you so much. In fact, I think that was pretty good. Thank you very much. It is our pleasure. Well, I want to introduce our guest this evening, and we are very honored to have Professor Glenn Cohen from Harvard Law School be with us this evening, and Jesse Burbank. And I think those of you know he graduated from University of Kansas, attended Harvard University, and helped us, the Dole Institute, get Professor Cohen, and we're very grateful. So thank you so very much. I will just read brief bios for you so that you know. Professor Cohen is the Deputy Dean and the James A. Attwood and Leslie Williams Professor of Law at Harvard Law School, and serves as the Faculty Director. He is also one of the world's leading experts on the intersection of bioethics and the law, as well as health law. He also teaches civil procedure. He is an elected member of the National Academy of Medicine. He has spoken to NATO on biotechnology and human enhancement, addressed the OECD and members of the US and the Korean Congress on medical AI policy, and advised then US Vice President Harris on reproductive rights. I am skipping. His work has been frequently covered by or appeared in media venues such as PBS, NPR, ABC, NBC, CBS, CNN, and New York Times, the Washington Post, and the Boston Globe. He is the author of more than 300 articles in leading law, medicine, and science journals. And he's a co-editor of more than 20 books. He currently projects relate to medical AI. And, you know, one of the things, if you look at all these his credentials here, you will also see the therapeutic use of psychedelic drugs, research ethics, organ transplantations, and medical tourism, and many other topics. I didn't cover everything there because you can read the rest, but that's to show you that we have someone before us who knows health law. And we're very excited. So I will move on to Jesse Burbank. Jesse earned his bachelor's degree in history and political science from the University of Kansas in 2017. He was a member of the Dole Institute Student Advisory Board. And, you know, that's what Bill Lacey often would refer to as our student culture, that Audrey Coleman says, yes, that's our student culture, that Barbara Ballard says, yes, our student culture, and everybody else on our staff says, yes, that's our student culture, and they are a big deal for us. They are a player. We talk about basketball on this campus. Well, they are players. But they are players in terms of making sure that civic engagement, that we pay attention to current events, that we register to vote. And all last week was National Voter Education Week. And there were over 40 students out registering people at 5 different locations on this campus. That was just our kids, not all the other people on campus as well. Our young people are involved. So Jesse, I'll go back to him. I just had to add that when I got in the middle of it. So I would say he was Harvard Law School in 2020 and worked in private practice after law school at the law firm Sidney Austin LLP in Chicago before joining the U.S. Army JAG Corps in late 2022. He is now a captain in the U.S. Army, serving as a criminal trial lawyer in the military district in Washington, D.C. He was previously a federal prosecutor in the District of Kansas and a special victims counsel at Fort Riley, representing survivors of sexual assault and related offenses throughout the military justice process. You can see we have 2 very different people, one a student of the other, and now doing his own thing. And I don't know, that's the progression we should have. So I think you're in for a real treat this evening. And I thank you all so very much for being with us and joining us in the process. I will now start our questions. And because it is Constitution Day, I think we're going to do just a little 10-minute briefing on what is the Constitution in many ways, and we're going to get into health law. The first question I'm going to start with is Professor Cohen. Is the U.S. Constitution vital to democracy in this country?
That's an easy one because the answer is absolutely. Now, I wanted to just say for a moment what a pleasure it is to be with you, Dr. Ballard, but also to be with my former student. As a teacher, there's no greater joy than when you see your own students surpass you in life and eclipse you. So I'm happy that that's starting to happen for you, Jesse. Okay, but back to the Constitution for a moment. James Madison in Federalist 51 wrote, "If men were angels, there would be no need for government." Well, if governments were angels, there'd be no need for constitutions either, in that the Constitution is inherently a document that's meant to restrain some of our worst impulses and also to really be a referee between the branches and between the federal government and the state government. Most constitutions have a short shelf life. If you look across the world, the average number of years is 17 years. That's the average length that a constitution lasts before it's turned over. Ours in this country has lasted much, much longer because it's a testament to a particular vision of what kind of a country we want to be. But always, as with everything in American politics, it's a contested vision, and a vision that over time, means different things to different people in terms of who is represented by the Constitution, who is a person within the meaning of the Constitution. But it is fundamentally a document about the ways in which we ought to behave as a society, and we ought to behave electorally and politically. And while sometimes it doesn't show the ceiling of what we can be, it definitely gives us the floor. And in that respect, I think it is kind of deeply, deeply important for American democracy. And we saw that even today, where we have a case about the Voting Rights Act, for example. It continues to be relevant about what the terms of American democracy is, even all these years later.
All right. Would you like to add anything to that, Jesse?
Oh, certainly. First off, I'm sure you'll be hearing this disclaimer again tonight, but I don't represent any of the views of the military, of course, only my personal views and my personal capacity. So in addition to Professor Cohen's remarks about the longevity of our Constitution, the enduring nature of our Constitution, the Constitution, I believe, goes far beyond being a document. It's also an abiding set of values of those who constitute the United States. And without that buy-in from the people, without day after day living a set of democratic, small d democratic values coming together in forums like this one, engaging with people in civic life in any form, whether it's through your workplace or your church or your other community groups, that is what makes the Constitution meaningful and enduring. The goodness and the values of the people that every day are constituting the actual system that we're living. The Constitution itself, a document, words on a page, but without those who actually bring its values to life and those who safeguard it over the period of their lifetimes, then it wouldn't be a document worth much for very long.
Well, I will say, since that's the framework for the government, we have three branches. Why do we have three branches? Couldn't just one do it?
I mean, I think it is the genius, but also the fragility of the vision of the framers to have this idea of checks and balances. There are other countries where we have a single executive, or the executive and the legislature are the same entity. Here, much of the docket of the United States Supreme Court, especially I would say over the last period of time, is to kind of be a referee between the other branches and to make a determination about what is appropriate and the like. But the framers were afraid of the king, afraid of the sovereign, afraid of that kind of agglomeration of power. And there was a real desire to split it in a way that would be for the benefit and for the happiness and for the fulfillment of the people, right? And so it's a distinct vision. There are many things that it makes much more difficult than compared to other countries, but it is a vision that I think that we continue to subscribe to, but one that's constantly challenged because, okay, the moment when you have the power, it's very tempting to think that actually you'd like to steamroll around the other branches, or as the federal government, steamroll over the states who enter this country as co-equal sovereigns, as respectful, as deserving of dignity. And part of what I think restrains us from those tendencies is respect for this document, and as Jesse rightly says, the culture that goes with it, not merely the words on the page, not merely, as I often say, judges don't have armies. When they say something is unconstitutional, they say something is against the law, it is our own internalized culture of law and law-abidingness and constitutionalism that causes us to follow it. And that is a remarkable thing, but always a tentative thing and always a fragile thing, if you think about the long history of this country.
Okay, so we look at our three branches. So we say the legislative, we look at it in terms of they make the laws. Then we have an executive. They're going to enforce the laws. Then we have our judicial, and they're going to interpret the law. And we've often thought the Supreme Court was the last stop. So we look at that in terms of lots of power, all three branches have, but they also have limitations on what you can do in order to keep them in balance so that not one branch is more important than the other. But then we have the federal structures. And that's what I want to comment from both of you, if you choose to do so, on establishing a central government with powers that's distributed between the federal government and the state governments, okay? I serve as a legislator in the state government, but we look at the federal. So how do you break that down so that states also have power?
Part of it is that we have a constitution that reserves all powers not given to the federal government to the states. But it creates all sorts of interesting questions, in particular the power of the purse. And if I can invoke the Dole name, although I think it is actually Elizabeth Dole, right? One of the Supreme Court cases that has the Dole name in it is South Dakota v. Dole, which is about whether you can induce states to raise their drinking age, right, by conditioning the granting of highway funds to them. And just to bring back to healthcare, same question about Medicaid expansion. When the Affordable Care Act and Obamacare came out, could you basically get states to expand Medicaid by saying, if you fail to do so, we're going to change the terms in important ways about how Medicaid is reimbursed? And this is a tension because, again, you have the states, and there are many of them, and some of them are bigger, some of them are smaller, right? But the sense is that the federal government is this behemoth, this idea that it might actually roll over the states. So part of what the Constitution does is it reserves space for the states to make decisions, and both in terms of the Constitution itself. State constitutionalism is extremely important as well, in that whether you are somebody who's a progressive or a conservative, you will find solace and protection for things you like and visions of the world that you like, not just in the federal Constitution, but in the state constitutions as well.
One key premise of the Constitution that the founders thought of was ambition checking ambition. Now, that's most obvious between the three branches of government: the legislative checking the executive checking the legislative, the judicial checking them as well. but that also operates in the context of federalism. The states are often a check on the power of the federal government. You see that come up in cases like the one Professor Cohen referenced. The states have certain rights, all non-enumerated powers that are not expressly given to the federal government in the Constitution are reserved to the states. That could include the police power, that could include certain powers over different forms of taxation. And ultimately, it ends up being a very important check on too much power being centralized in the hands of too few. State legislators, state governors, state supreme courts, they also play an important role in checking power from being too concentrated in the hands of too few people, which ultimately was the founders' animating concern behind a lot of their design. Now, Representative Ballard could probably have a unique perspective on that checking role, in her capacity in the Kansas State House, but it's part of the brilliance of the founders and their ultimate design.
All right. We're going to get into health law. We just wanted to give you a brief review of what democracy and the Constitution stand for. Because often people will say, well, why do we have Constitution Day anyway? Well, part of it was so that people know what's in our Constitution. They're supposed to abide by it. We're supposed to respect it. It protects all of our citizens. That's where free speech comes from. And yet sometimes we have a difficult time keeping a balance. So I will say, to start off, I will ask Professor Cohen, could you talk about your upbringing? You don't have to tell us everything, but education, and what led you to your academic focus in health law?
Sure, I'll give the very brief version. So I like to say I'm the proud child of two high school dropouts. Neither of my parents finished high school. My father had to work and my mother married. And I say this in part because my view is that wisdom, intelligence, and all this, while it's great to go to university, and we're here at a university, it is not limited to people who go to university. My parents are incredibly wise, smart, successful people who I respect deeply. Even though they didn't have the educational opportunities that I did, and I'm very grateful for. I grew up in Canada. I'm a Canadian by birth. I've naturalized in this country. Canadians have always been obsessed with healthcare in a way that's only recently come to this country. I will say that I was torn between going to medical school, doing a philosophy PhD, and going to law school. I ruled out medical school very early when I didn't want to take organic chemistry in college, and I was like, that's definitely not going to be for me. But I thought seriously about a PhD in philosophy, and my father said to me, why don't you do law school first? You'll always be able to make a living. You can always go back and do that PhD. And I never did, although I read a lot of philosophy. But for me, what I love about healthcare, two things. One is I'll say I'm a fairly intellectually lazy person, in that if I was a scholar of the Establishment Clause of the Constitution or the framers of constitutional history, I would have to read a huge amount, and to find a small space for me to say something new would be extremely daunting. Whereas in healthcare and the space that I work in, the problems present themselves and new technologies come on board, and I can often be the first person to say something about something. And to me, that is incredibly exciting. So that's one reason. The second reason is, and I was an appellate lawyer and I was a gladiator for a time, but I'm actually a person who believes in trying to find overlapping consensuses and spaces for agreement. And healthcare and the health of a population has historically been a place where actually we all have the same goal and we all have the same enemy. The enemy is disease, the enemy is dysfunction. And to me, that's a wonderful space to be in as a lawyer, as opposed to thinking that every win that I get is a loss for someone else. Those are the things that have attracted me to that field.
So I'll sort of swap off questions.
Please, yeah.
Here. So health law professor, of course, it's a very broad field. Could you add some texture as to what health law means?
Yeah, so I say that we're basically the largest chunk of the GDP. I can't remember what it is now, but it's a significant, maybe it's a fifth of the GDP is spent somewhere in the health space, right? So we are the lawyer that deals with most of the things you spend money on. That's one way to think of what we do. But essentially, I would say there are people who specialize in topics about ethics and contested questions like abortion, reproductive technologies, end-of-life decision-making, transgender populations and gender-affirming care, for example, questions about clinical care, questions about advanced directives. So that's one bucket. Got a bucket of people who work about law and psychiatry, the question about commitment and involuntary commitment of individuals, fitness to stand trial, forensic, when somebody is able to make a will and the like. That's another bucket. Got a group of people who are interested in the transactional side. You have large hospital systems that we know from the state legislature and Medicaid and the like are a huge part of the budgets. How do they operate? What happens when they want to acquire another piece of it? What kinds of conflicts of interest might you have between various physicians? What roles for billing? How do you fund and hopefully do in a way that is responsive to people's needs an insurance system? And then you have other areas as well, including public health law, which is the question about what may the state do to further the health of the public, everything from determining what taxes should go on alcohol to questions about masking policies during COVID, for example, and the like. All of these are much more as at the umbrella of health law. And what I like about it as a field is that you need to learn tons of different sources of law, not only statutes and regulation and state law and contracts and the like, but also, as we'll talk about today, constitutional law, which has become increasingly interested in the health space.
All right. Well, maybe the highest profile health law case in recent years was Dobbs versus Jackson Women's Health, overturning Roe versus Wade, and Planned Parenthood versus Casey. Talk about the court's reasoning and the impact of Dobbs.
Yes, so thank you. So first of all, the Dobbs decision, essentially a majority of the court determined that what had heretofore been thought of as a constitutional right under the federal constitution, a right for women to have abortions before the point of viability, that was the rule in the Casey decision, basically determined that that was not compatible with their understanding of the Constitution and a version of the constitutional theory which was connected to the traditions of this country, and whether this had been something that the majority had said that the Roe v. Wade had sort of made from whole cloth. The dissent vociferously disagreed, suggested this had actually been deeply rooted in the experience of individuals and also part of a vision of constitutionalism where protecting the rights of one sex in terms of these decisions as well as control of one's body was extremely important. So all of that's in the opinions. In terms of what the effect's been, it's been quite interesting, I would say, in that one interesting finding, kind of a startling finding, is actually the rate of abortions overall in America have not gone down in the wake of the Dobbs decision. That's what the empirical evidence suggests. But the way in which people get abortions is quite different than it was before Dobbs. Majority of abortions now are done through medical abortions, usually a two-drug cocktail, mifepristone and misoprostol is how we do it here in the United States. We've also seen significant questions about travel between states. So basically the idea or the vision of Justice Alito, who wrote the majority opinion in Dobbs, was to return this question to the state. And I think there's a way of reading the opinion of being very optimistic that in so doing, we're going to take away this area which has been one of deep political contestation, and finally we'll just allow people to kind of make up their own minds and allow the states to make up their own minds. The problem is that actually states abut one another, and it turns out most of us today in this nationalized economy move between places. So what do you do when an individual is in one state but wants to go to another state to get an abortion? What kinds of restrictions can be placed on that? Does it matter if they're a minor? Does it matter if a drug is flowing into the state? Can you get information and subpoena records from the place where they go? Can one state seek to extend its criminal law extraterritorially to reach the activities of its citizen in another state? These are all hard questions that we didn't really have to face before Roe v. Wade, but now they are not only hard questions, but questions that will take on constitutional significance. And slowly over time, the Supreme Court and the lower courts are facing more and more of these questions as the states begin to experiment. At the same time, this has also been an amazing moment for what one might call popular constitutionalism, and that in the wake of the Dobbs decision, we had many states, including this state, express their views via referenda, via elections and the like, and really take positions on this, and sometimes quite nuanced positions on their views about abortion. But it hasn't made the situation less complicated, is what I would say. Instead, I think we're living in a complicated time period, and a period of time where access to abortion is not evenly distributed. And there are people who would very much like to have access to that, they may have to drive 500 miles in order to get an abortion, which is a very difficult thing when you're in a particular kind of family situation, for example.
It's also, I would note, been an interesting realm for state Supreme Courts too, like the Kansas State Supreme Court finding a right within state constitutions. Next, Professor, let's turn to an equally anodyne and uncontroversial topic of gender treatment for transgenders. So we've seen the court recently address this in the Scrimeti case. Could you talk about what was at issue there and where the court came down and where that field might be heading?
Rather glad they gave me a glass of wine before they started the third degree tonight. Here we go. So first of all, full disclosure, I was an expert witness in one of the cases, not Scrimeti itself, but one of the sister cases on a fairly narrow question in this, right? So I'm not going to speak about my own expert testimony. I'm just going to give my views about the Scrimeti decision. So the decision was essentially the question about whether a law that prohibited access to gender-affirming care, drugs in particular, to minors, people under the age of 18, if those same drugs, they might have been approved by FDA for one indication, but they were being used for one purpose, that is to allow somebody to engage in gender-affirming care, to receive gender-affirming care, that is to help transition their gender, versus the same drug might be usable by a person for like precocious puberty or something like that. So single drug, two different uses. And the law in question in Scrimeti essentially said, if the use is for the purpose of engaging in changing one's gender, just to put it in lay terms, that is not permitted, whereas these other uses are permitted. And then also said that among the reasons is we want people to respect the gender that they're assigned at birth and to honor it and to avoid all of this. Okay, so the question before the Supreme Court was, does this violate the Equal Protection Clause of the 14th Amendment of the U.S. Constitution, which protects, among other things, discrimination on the basis of sex and perhaps also on the basis of transgender status? The justices did not come to conclusion on that latter question in the Scrimeti case. A couple of the justices expressed very explicitly they thought that protection on the basis of transgender status only gets the lowest regard in terms of constitutional scrutiny, rational basis review, whereas others said we don't have to decide this question, and others felt differently about the question. But on the basis of sex was quite interesting because the Supreme Court had previously decided a couple of terms before a case about employment discrimination where they say when you refuse to hire someone on the basis of them being transgender or them being gay, that is discrimination on the basis of sex in the sense that had their partner been different or had their sex been different, the result would be different. And so if we prohibit on the basis of sex, we ought to prohibit that as well. And the question in Scrimeti was this particular ban on the drugs like that prior employment law decision, and is the Constitution interpreted in the same way of Title VII? And what the court ultimately said, and again, if people ask me, I will tell you my views about the quality of the decision-making, but I'll just say, just to kind of lay it out in a direct way, this was not discrimination on the basis of sex. It was, on the one hand, age-based, in that people over the age of 18 could have access to these drugs, so there was an age-based version. And really, it was about medical treatment. And so to say, you can have it for this treatment, but not that treatment, that's all this distinction drawn by the states was, such that it was not discrimination on the basis of sex or distinction on the basis of sex. And the problem with the argument, or a potential problem with the argument, is that it turns out everybody who wants this treatment is of one sex, and everybody who wants the other treatment is of the other sex. And the court actually made reference to old decisions, Gedaldig, which is an old decision, a footnote in that decision about pregnancy discrimination, where they say, this is just like pregnancy, that when we don't give people pregnancy leave, that's not discrimination on the basis of sex because there are women who don't get pregnant. True, but it turns out there are not men who do get pregnant, right? And this is one of the things that the dissent points out and it really hammers home. So I have my own views about the case, but that's essentially what the case was about.
Let me follow up on
Sure.
that. Okay, this case actually is dealing with sex mostly, okay? But what about the Equal Protection Clause?
Yeah, so the question is, what does the Equal Protection Clause protect? And this is often a question of what is a suspect classification or a quasi-suspect classification. The Supreme Court has said historically, discrimination on the basis of race clearly merits the most searching regard in terms of its constitutionality, strict scrutiny. When it comes to discrimination on the basis of sex, intermediate scrutiny, which is still pretty searching and pretty demanding, but not quite up there. And the question is, what about discrimination based on sexual orientation or about being transgender? And here the court did not resolve that question. Some of the justices made very clear that they think that does not get heightened scrutiny. And just to return to the theme of this being Constitution Day, one of the main theories of the Equal Protection Clause, when we ask, what is it, who gets protection, who needs protection, is a recognition that ours is a counter-majoritarian constitution. It is to protect the rights of minorities because majorities can often have their way through the political process. And one of the questions is, there's this famous footnote called Caroline Products footnote 4, where the court says, are you a discrete and insular minority? Are you someone who cannot carry the day in the political process? Those are the people who need the most protection under the Equal Protection Clause, because it's very tempting for a majority just to steamroll over them. And the Supreme Court, at least the justices who expressed a view of this, said, some of these categories are like that. Transgender people, they're not a discrete and insular minority. And Justice Barrett writes, and again, without editorial comment just yet, if you ask me for it, I will give it to you, but basically writes that the problem is that they do not have a history of discrimination from the laws. There may be social discrimination against transgender individuals, but not a history, she says, of legal discrimination. I think that's not a correct representation about the history of this country and the history of the laws of this country, but that is an important part of her conclusion as to why transgender individuals do not get the protection of heightened scrutiny.
So just to sum up, Professor, is it correct to say that the Supreme Court made this decision on the basis of this being a law that regulates certain forms of medical treatment for certain age groups, and opted not to categorize it as an equal protection question, and then some of them said what they would have said had it been cast as an equal protection question?
98% agree, except the 2% of this, I'm a professor, so I obviously have to disagree a little bit, right? The 2% I'll disagree is to say it's still an equal protection question, but the question of what level of scrutiny under equal protection you get. Because even when you say something is reviewed for rational basis, that is still a question of equal protection. It's just not a very hard one, because when it comes to this rational basis review, this is a category where the state can do what it wants, more or less, as long as it has even just a little bit of a rational basis behind it.
The nuance of the student and of the professor.
And I appreciate that, because somewhere along the line, in whatever decision they were making, the Equal Protection Clause didn't seem as if it was being considered. And that's why I brought it up, which forced me to go for the last 3 days to read, because I wasn't aware of all of that it entailed, because I'm not in law, but I've had law classes, just enough to be dangerous but not know anything. So, I mean, that became really
Well, even because I often say I play a doctor on TV, but not in real life.
Well, I just wanted to. Well, we're going to give you another one. We've also seen the court address health law arguments in the context of gender-related interventions. Yes, we've talked about that. But religious liberty and speech arguments sometimes feature in health law cases, including in pending case that Colorado has right now on conversion therapy ban. So what's your comment about that?
Yeah, so this was just argued, I think, last week or maybe earlier this week, or very, very recently, the Child's case. And again, full disclosure, I have an amicus brief with some other health law professors in the case. Essentially, in that case, the state basically prohibits a counselor from engaging in what is called commonly conversion therapy, which is basically to counsel someone to change their sexual orientation or to stop being transgender and the like. And the question was, if a state restricts a therapist's speech in this way, does it violate the First Amendment of the Constitution? And interestingly, in particular, the freedom of expression part of the Constitution, and that the case was not litigated at this stage about religious freedom, just about pure speech. And listen to the oral argument. You can make guesses. Sometimes you're wrong, but I will say it seems pretty clear to me the Supreme Court is going to say that the Colorado law is going to be subject to strict scrutiny, and might go further and say we don't even have to remand the case. It's clearly unconstitutional. And the theory is that this therapist has a right to speak, and this is not just any restriction on speech. It's either what's called a content-based restriction on speech, which means we're picking out a particular content and say you can speak, but not about that. Or perhaps even worse, it's a viewpoint-based form of speech restriction, which is to say, not only can you can speak about conversion therapy, but only if you're going in one direction, not in the other, right? To say a particular viewpoint is going to be raised and a particular viewpoint is going to be lowered, and that's not appropriate for the state to do. So I will say historically, this is one of the most free speech protective Supreme Courts we've had probably in the history of the country. Maybe there's a couple of others over the years, but certainly as of late. And what's interesting is that I think the decision will actually be 7-2, not 5-4, and that I think even some of the liberal justices will come to this conclusion based on the oral argument. Whether they're right to do so or not is another matter, and I'll just tell you the concern of what motivated the amicus brief that I participated in. States, turns out, as part of regulation of health professionals, regulate many things that could be described as speech, right? If a therapist hits on a patient, for example, and makes sexual advances, that's the kind of thing that can get you to lose your license. That is a form of speech, right? Requiring informed consent, you to explain something to someone as part of a procedure. That is a form of speech. All sorts of things are speech and also treatment at the same time. The entirety of psychotherapy, in some ways, is the belief that these are words, but they're also treatments, and they're treatments that might be just as powerful or just as impactful as prescribing a drug. And so it's quite strange to think that while the state, as in Skermeti, can make a decision as to whether to allow a particular drug to be used for transgender individuals, the state can't make a decision about what kinds of speech can be deployed when dealing with transgender individuals or gay individuals in the context of therapy. It seems like what's sauce for the goose is sauce for the gander in this respect. And the idea, there's a risk that if the opinion is written in the wrong way, it might suggest all regulation of professionals in when they speak to the public is going to be unconstitutional. So before I became a professor, I was an appellate advocate, so my job was sometimes going before the courts and dealing with exactly these issues. And when you're there and you know you're going to lose, you try to lose in the way that's going to do the least damage. And I hope that's going to be true for the Supreme Court as well, that if they are decided that they want to overturn bans on conversion therapy, that they write the opinion in such a way that it doesn't call into question the entire regulation of therapy, which is something that I think is very important because therapists are medical professionals just like physicians, nurses, and others are as well.
As you can see, we have many questions. We're going to have 2 more questions, and then it's your opportunity to ask your questions as well. Go ahead, Jesse.
Well, can I just say, lose in the way that does less damage? That's now words to live by as a criminal defense attorney. So thank you for that. Professor, Obamacare, we can't let a program about healthcare pass without it. Many constitutional insights have flowed from Obamacare since it came into being back in 2010. Could you give just a brief overview of some of the most important in your mind that have come from that case?
Yeah, there are, I think, 3 cases that come to mind real quick, and I'll just talk about them, or 3 aspects of cases that come to mind real quick, and I'll just talk about them quickly. The first 2 relate to this question about the power of the federal government versus the states. And the initial litigation over Obamacare was all about whether Congress can use one of its enumerated powers, what's called the Commerce Clause, to essentially regulate insurance in the health insurance market. And the Supreme Court ultimately decided the answer is yes. Along with that decision, though, was a second question about the Medicaid expansion. Could Congress incent, or, if you believe the critics, coerce states into changing their Medicaid programs by changing the terms of the deal by which Medicaid would be reimbursed over time? And there, the Supreme Court essentially said that you can do that to a point, but not further than a certain point. And that actually invoked the Dole decision, which is the prior decision in this line, the only other case really on this question about what's called unconstitutional conditions. So both of those are aspects about the relationship of the federal government to the state government, and in particular, when the federal government oversteps its bounds by interfering with the way in which states regulate healthcare markets, because states are the primary regulator of healthcare in this country. The third decision, though, is a set of decisions about religious freedom here, and this question about whether various kinds of mandates, for example, for contraception and the like, enforcing of coverage, violate the constitutional or religious freedom restoration acts and the like. And this continues to be an ongoing and active piece of litigation. that I think is worth keeping an eye on. But we had a series of cases on that as well. I think the most interesting thing is the way in which constitutional culture can precede or follow popular culture, in that when people talked about the Affordable Care Act, possibly an Orwellian name for the statute when it looks what it actually does, right, in terms of its actual principles. When you look at the time, it was deeply contested. It was like a hard-fought victory. One remembers John McCain with the famous, thumb up or thumb down in the votes and this accusation. Today, in the current moment, it is an incredibly important backbone for the way many Americans get health care. And I think we're seeing this currently in the shutdown. The shutdown is essentially being fought in some ways over the question about whether to subsidize health care for poor Americans. And it turns out that actually the way in which things are distributed are quite interesting, and that the Democrats are fighting for the subsidies, which will mostly go to Republican states, and the Republicans are in the midst of shutting down the government in a way that will mostly cause money to flow away from Republican states if the Obamacare, the supplements kind of go away. So to me, though, this is like just a reflection of the idea that something which is treated as strange, new, constitutionally suspect, over the period of time can become part of the fabric of our country. And I think we've seen that with the Affordable Care Act.
All right. And my last question, so get ready.
Sure.
So I would say, trying to make sure I word this right. We've seen some major health law questions resolve on technical grounds related to standing. Talk about what standing is and the role it played in major health law cases like Alliance for Hippocratic Medicine.
Great. Okay, so very briefly, standing is whether you are the kind of person who can bring this lawsuit. Does this lawsuit belong to you, right? Do you have an interest and the right kind of interest in the litigation such that we believe you are an appropriate person to bring this lawsuit? And believe it or not, a part of the doctrine finds itself in the Constitution, in Article 3 of the Constitution. And the idea behind it is we don't want people to be like throwing the match, right? We don't want people coming into court who don't really have a reason to be there. We don't want to invite the doors open to people who have no skin in the game on the one hand, or we don't want cases to be adjudicated when there's not a real live controversy. And it has two sister doctrines, mootness and ripeness, but for standing. So the case you reference was a case the Supreme Court took up at one point relating to mifepristone. So mifepristone, again, is the drug used in about 60% of abortions in America. It's medical. It's been hugely important in the wake of Dobbs. How most women get abortions is through this drug. And there was a group of enterprising conservative litigation group challenging the initial approval of this drug, even though the drug had been approved many, many years ago, even though it had been reviewed many, many times, and also various changes in the access to the drug that had happened over time, including making it available through telehealth rather than having to go to a physical appointment. And the Supreme Court essentially had this case in front of it. And the Supreme Court did what I think was the smart thing to do, which is to say, you all want us to answer this question about FDA law and about health law, and maybe there's some constitutional law in there. We're just going to decide that we're not supposed to decide this case. And the reason is because the people who have come forward, their argument as to why they're here is they say they're physicians, and maybe if someone takes this drug and maybe if they have an adverse consequence, well, then maybe down the road that physician might have to perform an abortion, and that physician is against abortion. So, and the Supreme Court basically said, you know what, gosh, that's a lot of maybes. And we don't want to essentially have litigation on maybe this, maybe this, maybe this, maybe this. We require a much more particularized injury and one that will be redressed by our decision. And as a result, the Supreme Court essentially vacated the prior decision in the line. The case was remanded. Now, the story's not over. The states have now gotten involved and claimed that they have standing, and there are some cases flowing out. But at least in the meantime, the Supreme Court was able to avoid a question that some thought was complicated. I didn't think the actual merits question was complicated, but I have a dog in this race, so I want to kind of be aware of my own priors on the subject. But certainly the Supreme Court was able to avoid it, and this is also a form of restraint envisioned by our Constitution, in that while we often think about the Supreme Court and the judiciary as the expositor of the Constitution, there's a way in which they too can step over the line. They can grab things that doesn't belong to them. The standing doctrine is meant to be a restraint on them and was evinced in this case.
All right, thank you. For those of you online, if you have questions for us, we have someone that's on the computer, we're looking for them, and it's dolequestions@ku.edu. dolequestions@ku.edu. And who are our students with the microphone? We'll come to you if you have a question. So, who would like to be the first person to ask your question?
Hi, my question's for Professor Cohen. I'm not super knowledgeable on the conversion therapy case, but I believe that the state of Colorado made an attempt to draw a distinction between state-licensed mental health professionals and those that were not possessing a state license. Can you talk about any implications with precedents on that specific question?
Yeah, so I think what you're referencing to is that actually there's the thing that the Colorado law, as I understand it, didn't reach, for example, life coaches, for example. That was like a category of people who were left out. There was a question about which way this cut in the litigation, because you might say, if the state is really concerned about people performing conversion therapy, why are they not also seeking to restrict the speech of life coaches on this subject? And the answer, I think the state, they certainly gave this answer at the oral argument, whether it's your mileage may vary on it, is that licensure is a particular kind of relationship. It creates all sorts of expectations in a person, creates fiduciary or quasi-fiduciary duties to a patient. It might generate malpractice liability and the like. And also, the state has the power to license medical professionals. That's one of its key powers, and the police power, and the public health power, and the like. And I think what Colorado said was, it is true that we haven't licensed these other people, but actually that's not a mark against our law. If anything, that's a mark in favor of our law, that we're viewing this as part of our regulatory practice, right? That it's not an attempt to stop people from talking politically about whether conversion therapy should be a good idea. It's not an attempt to restrict people from having votes in the legislature or having debates on it. All we're saying is that we are allowed to take a view of what the medical consensus on this question is. And our view is that the medical consensus suggests this is not helpful and actually harmful for minors. Now, if you permit me to just say one more remark in this line. One of the things we've seen, so I said with my personal biography that one of the things I liked about health law is it was collaborative, non-contested, lots of overlapping benefits, disease, dysfunction was the enemy. I do think parts of that consensus have unspooled over the last decade. I think for many, actually, COVID was a turning point where the idea of the medical profession and medical consensus, certainly for some who were skeptic about some of the measures of COVID, has now congealed into something like don't believe the science. And we're seeing this politically right now at the current moment, that this is also a reflection in constitutional culture of a particular attitude towards truth and in particular towards medical consensus. And I think you saw that even at the oral argument about conversion therapy, in that there was lots of questions poised to say, why should we believe the doctors who said they formed this consensus? How do we know they're wrong? Shouldn't the Constitution leave space for minorities and minority viewpoints in this thing? And that's just an interesting moment, an interesting change, I think, in the sort of climate of the attitude towards medical profession.
Other questions?
I address this to either or both of you. A report was issued today by HHS from the group called Make American Children Healthy Again. The focus was on the causes of children not being healthy and how to solve that. One of the main areas of focus was on what it called the over-medicalization of children. Would you comment about that?
I don't know if your views, if you want to go first. I've talked a lot already.
Well, I don't really have a particularly specialized viewpoint on that, I would say. But from the point of view of a layperson, I could see sort of intuitively what they might be gesturing towards in that report. As time has gone on, especially during COVID, you might say, at least in the popular imagination, there is a sense that children are living too safely, children are living in too sterilized of spaces, too safe of spaces. Children are sort of confined indoors and encouraged to be safe from the elements outside, from sort of threats, real or imagined, outside. And ultimately, that could have really negative impacts on both the physical and mental well-being of kids, whether it could be development of allergies from just simple non-exposure at an early age, or whether it is leaning into other pathologies that are found in spaces that are perceived to be safe, like maybe you're going on your phone all the time instead of going out and getting sort of natural forms of medicine, like exercise or sunlight or anything like that. I can't speak to particulars, and I know that HHS is, they're doing their big old push towards making America healthy again, as the department believes. But I think that that is probably, at least in the popular mind, what that report is addressing.
Maybe I'll say two quick things on this. One is to say, I don't doubt that there are children that are on too many drugs and drugs that are not helping them and the like. I do also worry about the under-medicalization in the following sense, in that access to health care for children, for immigrant populations, for women and maternal care and the like, is a huge problem. So to me, it would be really sad to live in a country where there is both huge amounts of over-medicalization and huge amounts of under-medicalization at the same time, and they're not distributed randomly. The other thing I'll say, and I promise I'm not working the ref on this, is that I'm actually also quite worried about over-medicalization of older populations, in that I have parents who are in their 80s, and I will say that one of the interesting things is there's some emerging concern about falls. Why is it that actually the rate of falls and actually the dysfunction coming from falls is actually greater for this generation than other generations, given changes? It's not changes in body composition necessarily. One of the concerns is that actually many of us are put on a drug at some point in our life, and it turns out as our body composition changes and as we get to older age, it turns out that some of the negative side effects, especially as towards dizziness and falling, is not something that's thought about, and we stay on the drugs long past when we're going to get the benefit. So I'm also worried about over-medicalization at the other side of life, too.
Okay. We have two questions in front.
Since we're actually at the Dole Institute, there's a little thing over there about Dole creating the ADA, Americans with Disabilities Act. A question just about health related to people with disabilities, but also with NIOSH, the National Institute of Occupational Safety and Health, and OSHA, Occupational Safety and Health Administration, under the OSHA Act. A question about, or just comments about, legislative branch creating these and yet being underfunded and not enforced from the executive branch, and where that's going and the damage that's going to cause to the health of Americans.
I think occupational safety is incredibly important, but has always been the ugly redheaded stepchild. Sorry to redheads here. The ugly redheaded stepchild, to use the phrase.
Broadside.
I'm glad you were his professor.
Of American health and safety kind of things. And that, as you say, my view is that it has always been, certainly in this particular moment, but it's been chronically underfunded. And when we think about how many pollutants and how many toxins and how many dangers we're exposed to at work, it's quite remarkable. Actually, weirdly, the place my work intersected this, of all things, I did a study about 4 or 5 years on the health of NFL players. And one of the things we were looking at was how OSHA standards might apply to NFL players as a workplace, because it turns out being an NFL player is a workplace as well, like anyone else. On the American Disabilities Act, I think it's a slightly happier story, not a completely happy story, but a slightly happier story. The Americans with Disabilities Act was an amazing piece of legislation that really caused a sea change and really changed the way in which we think about what it means to be a country that is inclusive. That said, I will say that there are many limits to the act, and we've had modernizations over time. But the Supreme Court was offered an opportunity in the Cleburne case to decide, now back to the question about the Equal Protection Clause, to decide whether people with disabilities are a suspect classification that deserves extra protection because they are discrete and insular, and because actually mobilizing political power as a group, people with disabilities, is quite difficult. The ADA is the exception for the most part. It's not a group that has had huge amounts of breakthroughs in terms of political power. And the Supreme Court decided that actually, no, they only receive rational basis reviews, such that as a constitutional matter, we tolerate large amounts of discrimination against people with disabilities in a way that might not comport with the better angels of our nature.
Okay. Other question I saw here?
My mother's a redhead, by the way. I'm just going to say that. Okay, good.
Thanks. I have a two-part question. Healthcare providers are just like everyone else. Some lean conservative, some lean more progressive. Wonder if you could talk about the intersection of healthcare providers' rights with the Constitution. Can a pharmacist be compelled to distribute mifepristone, or can a physician who knows and is trained how to do an abortion be compelled to do that? That's part one. Part two is more about a corporation who leans one way or the other. Corporate personhood, the Hobby Lobby case, can a privately held company, what are the rights to write their insurance plans or cover things in such a way regarding contraception or whatever? Yes.
So when it comes to the healthcare provider, I'll say with the pharmacists, I know a little bit of the answer, but I'm less confident, so I'll start with the healthcare providers. I'll say that federal law is incredibly protective of conscious rights of healthcare providers vis-a-vis abortion. And so much so that actually one of the reasons in this case where they decided there was no standing, they were able to say there was no standing, is because the Solicitor General got up and confirmed, when the court puts this in its opinion, that essentially it is extremely, extremely, extremely rare, if it's ever happened in the history of this country, that a healthcare provider would be compelled to provide an abortion against their conscience. With dispensing laws, it's a little bit, my understanding, a little bit more of a patchwork amongst the states and the state laws here. But on that one, I'm not certain enough that I feel like I could give a good scholarly answer. I will say, though, in general, physicians and people in the healthcare world have very conflicted and ambivalent feelings about some forms of regulation. Although the forms of regulation I think they're often the most ambivalent about are ones that kind of govern and structure their financial life and their commercial life, as opposed to their moral life, in the sense of what is a conflict of interest? When can you own both a clinic and also own the physician practice and refer people to one to the other? What counts as healthcare fraud? These are actually, I think, spaces where we see more contestation, but not in the register of morality so much as the register of kind of, this would be a helpful way to organize my business. Why am I not allowed to do so? And can I challenge it? So maybe I'll rest the answer there. Oh, yeah. So on this, I want to be careful not to get over my skis, because I'm not an expert on corporate speech rights and the like. But in the cases that I referenced, some of the Obamacare cases, there were questions about how to think about the religious interests of a corporation and a closely held corporation. So in the Hobby Lobby case, and then in the Little Sisters of the Poor case. I'll say, maybe just to don my philosopher's hat, or my would-be philosopher's hat, I think one very complicated question is a theory about complicity, that you have to have a theory about what it means to make you complicit in an activity. And that's actually just a hard thing to work out. We know, because we have cases like this, it's not enough that I pay taxes, so you are against the Gulf War, the fact that your tax dollars go to support it. That's not enough for us to think that that gives you a standing to challenge the Gulf War, or that you can say, don't use my money for that. So that's on one side. On the flip side, highly complicit if you're forced to undertake the activity that you disagree with, like perform an abortion. In between, though, are these very interesting and difficult cases. So, for example, if all you need to do is fill out a form, and by filling out that form, you're never asked to do the act, is the filling out of that form a kind of complicity or a kind of involvement because you've disclaimed it? It seems to me that we would do well, but this is now a political, philosophical view, not a legal view, that when you think about the range of cases around, you have to have a theory of complicity that's stable across many different kinds of cases, cases where you're aggrieved, cases where someone else is aggrieved. And as a political community, I think all things equal, we would do better with more narrow rather than broader theories of complicity, because I think the more we think of ourselves as complicit and involved in other people's actions and other people's lives, the less space we have to flourish and to really be the people we are. That I actually like the idea of separation and like the idea that there's many things that you do that I have no say over whatsoever, and to ask the same thing from you. So that's a kind of libertarian impulse I have about complicity.
All right. Do we have any questions online? Any other questions? Yes.
And I'll actually have one as well.
Okay.
Professor Cohen, I can tell you that you're a proponent of population health. You made a couple of comments like that. You know, we still have, I think, around 30 or 35 million people in the United States with no health care coverage. Is there not anything in the Constitution that would help drive that kind of coverage, or is this a miss by the writers of the Constitution not to address health?
So I'll answer the first question, which is descriptive. Is there anything in the Constitution that answers the question? No, there's really very hard to find in the Constitution any obligation to provide health care. Although I often quiz my students, this is a very dark thing to say, so get prepared. Where is the one place in the United States where you have a constitutional right to health care? And the answer is in prison. Because under the Eighth Amendment, we are actually, because we cut off people from access to any other form of health care, we have a constitutional obligation to provide it, and provide it to a certain level. So, as I said, a rather dark observation, but actually also true. In terms of, we are and again, I grew up in Canada. We are an outlier compared to all of our peer countries. But what's really remarkable of an outlier is that we spend just as much, if not more, and we get less out of it. So it would be one thing if that we were both making a political decision not to expand coverage, and we were not spending nearly as much as we were able to invest that money into something else. Now, it's a complicated story why we spend so much. Part of it is that we fuel the innovation ecosystem for drugs and devices across the world. We cross-subsidize with much higher premiums, and so it's not like a simple kind of answer. But one thing I will say is that when you look at life expectancy and social determinants of health and the population health aspects, things like diet, things like alcohol, things like smoking, we're not doing great there at all. So even apart from health care, there are things we could do without universal health care that would make us better poised to improve the health of our population. And indeed, I think part of what we've been seeing over the last 30 or 40 years is more of a recognition that health care is really important. Physicians, doctors, nurses, hospitals, they're great, but actually they often jump in at a fairly late point in the process of getting sick. And the more we can do up front, including supporting healthy lifestyles. And this is, and I'll just say, and I've been rather pessimistic and dark, but I will say that there's an interesting convergence here at the political moment in that Secretary Kennedy and I disagree on many things. But even framing the idea and the goal of making America healthy again and making America healthy, to me, is in some ways a buying into this vision of population health and social determinants. And so my hope is that this is a space where there can be more political convergence between the sides.
Now, Professor, I have one sort of future-oriented question for you as we sort of wind towards the conclusion of the program. You're a great observer of trends and in some ways predictor of trends. What do you think are going to be the greatest sources of legal and ethical questions related to healthcare in the future, particularly healthcare technologies?
I feel a little bit like the drunk looking for the keys under the lamppost, because I'm going to tell you about the kinds of stuff that I think about and I work on. So there we go, right? So this is a drunken answer to you, Jesse, to a very good question. Yeah. I think that, so I'm very interested in the integration of artificial intelligence into healthcare, and I think that we're going to see increasingly not just at the site of the point of care physician, but actually more interactions that we might have that might be mediated by technology, including interesting, difficult questions when we don't know we are dealing with an artificial intelligence. So the idea that we're thinking we're dealing with a human person, we're talking on the telephone perhaps even, or a video chat, and we're dealing with AI, and this could be wonderful or this could be terrible. It could be, when we think about our children and this generation and interactions with AI, there's ways in which we can expand their the kinds of entities they encounter and the kinds of people they encounter. On the flip side, we know many of the existing large language models are incredibly sycophantic, and they will basically reinforce our worst instincts or put us in dark circles. So I think this area is very interesting. I'm also very interested in the cutting edge of reproductive technologies. Of all the things I work on, I tell people that people think, so this will end. I'll tell you about one technology I work on that people think every time I talk about it that I'm talking about science fiction, but it's actually real. It's called in vitro gametogenesis, or IVG. And essentially, it's the ability, and we've done this in mammals, we've done this with embryos, we haven't done it to birth yet with humans, largely for legal and ethical reasons, but to take skin cells, so I leave a skin cell on this cup, you take that skin cell, and from it you could derive a sperm or an egg, including a cross-sex gamete, so female sperm and male eggs, and form reproduction and form embryos and form large numbers of embryos for this. So this technology would be amazing. Anybody who struggled with infertility as a woman knows what egg retrieval is like and how difficult this is. The ability to create eggs from essentially skin cells would be amazing. On the flip side, huge ethical questions about how we think about children conceived this way, embryo destruction, the commodification of reproduction. But to me, it's incredibly exciting that this is a possibility, even if it's used only for research purposes. This is the kind of thing that I think the people who write Star Trek couldn't imagine. So amazing that we're living it today.
Wow. Good. And my last question for you is a comment that someone sent me. Supreme law, no other law can be above it. It is the source of all government power and limitations. What's your comment?
You know, on where you went to school on Langdell Library, the Library of Harvard, it says, not under man, but under God and law. That's what the quote it says up there. So, you know, hopefully one of the two you're at least rooting for and you believe should have some governance on our lives, if not both. For some of us, it's both of those. But the idea that we live under the rule of law in this country rather than the rule of man, I think is an incredibly important idea that's baked in here. And for some people, it will also be a religious idea as well, that, you know, I think many of the great figures in religious, in most of the faith traditions are lawgivers. I think about Moses with the Ten Commandments, for example. That is an act of law giving and an act of law receiving. And we are wonderfully able as a country to also experience the secular version of that in the giving of this Constitution that I think also is a kind of holy document, but holy in the way in which we've received it and the culture that surrounds it. So an appropriate way to end Constitution Day.
Very nice. A round of applause. I would say to you, it was an honor for us to have Professor Cohen here this evening, and also Jesse Burbank, one of our own, who really, if I had not had his help, the Dole Institute had not been on his list, we probably would not have Professor Cohen here. So thank you to you as well. And again, thank you all for coming. And I hope you left a little bit smarter, maybe less pessimistic, but more hopeful, with a real determination to make life better for everybody. So thank you so much for being here this evening.